The second case on the docket for Wednesday, December 15th, 2021, is Appeal Number 121053, State of Kansas versus Joseph Miguel Valdez, Saline County. Briefs both sides. We are ready to proceed.
Counsel, if you would please come one at a time to the lectern to enter your appearances and then return to counsel table.
Your Honor, my name is Randall Hodgkinson. I'm appearing today on behalf of Joseph Valdez, and I'm ready for argument.
Your Honor, my name is Alex Driscoll. I'm appearing today on behalf of the state of Kansas, and I'm ready for argument.
Thank you, counsel. Mr. Hodgkinson, you may proceed with your argument.
Good morning, Your Honor. My name is Randall Hodgkinson. I'm appearing today on behalf of Joseph Valdez. I request 3 minutes for rebuttal, please.
Granted.
Your Honor, I would remind you that this is a possession with intent to distribute case out of Saline County, where my client was, law enforcement responded after my client had been shot and was requesting aid, and law enforcement came and gave aid, but also in the process, law enforcement found drugs, and the state alleged that those drugs possessed by my client with intent to distribute, and so we're here after that conviction and after the Court of Appeals affirmed Mr. Valdez's conviction. My first thing I wanted to talk about, Your Honor, was regarding the order that we got from the court last week. And first of all, thank you. It's, you know, a few days is better than walking in and not knowing. So hopefully we'll be able to talk to you a little more articulately. And also, an odd order for me to get, I feel like, in some ways, to say, well, is there this other possible sufficiency issue out there? Because this court knows, because you have cases of mine, where I've argued about the sufficiency of different kinds of things, even maybe sufficiency based on stipulations. And so as I reviewed the case and thought, well, what might I have missed here? Here's one thing that I saw as I reviewed it, is that my client was charged with, with regard to criminal possession of a firearm, that he had within 10 years prior had a conviction, and it was charged properly that he had a conviction under Article 57 of Chapter 22, a drug offense. And but the stipulation in this case, the evidence that the jury got in this case, simply said that my client was convicted of a felony, and it didn't specify that it was under Article 57 of Chapter 22, and therefore did not meet all the elements. And in fact, upon reviewing the case after getting the court's order, I mean, even the state recognized in their proposed instructions that the element of that it had to be under a prior conviction under Article 57 was an element. It was in their proposed instructions. It didn't end up in the instructions given by the court. So an effective stipulation in this case to affect really what I'll even admit was the purpose of the parties, the intent of the parties in this case, would have been that Mr. Valdez had been convicted in the previous 10 years of a crime under Article 57. And it didn't do that. And that was an element of the crime. And so I think that there is a real issue regarding sufficiency of that count. The second question the court asked is, what would the remedy be for that? Which is, you know, remedy for a sufficiency issue is vacating the conviction because it's a due process violation. I suppose the additional comment I need to make is, can you do that? Because I didn't raise that issue. And can you reach that issue? And certainly this court has, State v. Adams, 283 can. This court has reached issues before, even when parties haven't briefed them upon a showing. And that's exceptional, we recognize, although this is maybe a particular kind of issue that the court should reach, even if the parties don't, because it's always preserved. When a client pleads not guilty, you know, all the elements are put at issue, and to the extent that any appellate court sort of sees something like this, it seems entirely appropriate for this court to reach that issue if it sees so fit. So I'll pause there. That's sort of my response to the court's order.
Remind me, counsel, I'm going through my notes and I just can't grasp it real quick. In terms of where that possession of the firearm count came in sentencing, do you know whether that was concurrent or consecutive? And I guess I'm finding a consecutive 8-month term now when I'm looking in my notes.
That's exactly.
So if we get to it, if, you know, depending on everything else, it would have to go back for resentencing.
It would go back to
Just vacate.
You would just vacate that 8-month sentence, Your Honor. And I think you're exactly right, that there was 104 months for the possession with intent to distribute and another 8 months for the criminal possession of a firearm.
Why isn't the stipulation that of the conviction enough for a jury to infer that the elements were met? Because the jury found that the elements were met.
The elements that were given in the instruction were met, but that's not the elements of the statutory, it's not the statutory elements.
So that would be, but that's an instruction problem, not a sufficiency problem.
It's both. It could be both. I mean, this
Well,
could have also
but-
been an
but
instruction
I
issue.
guess that's the point of my question. Maybe the remedy isn't reversal, it's a remand for a jury to be properly instructed.
Just pausing to make sure I formulate my answer correctly, Your Honor, or as correct as I can. It's certainly true that you do a sufficiency challenge as you compare it against the complaint in a case, regardless of the instructions, I think.
And the evidence.
And the evidence, that's right.
Right.
I mean, you line the evidence up against the
Right.
charge. And the charge in this case was that Mr. Valdez had a prior conviction under Article 57. The evidence in this case that was presented to the jury, Your Honor, I want to be real clear. I mean, I understand that the underlying offense may have been exactly what the state says it was. I don't have any reason to disbelieve that.
Right.
But the evidence that's given to the jury that you line up against those elements was that he had a felony.
Right.
And that's where we think the sufficiency problem is.
And I'm just saying if, I guess, assume for the purpose of my question that the stipulation could be sufficient for a jury, for a reasonable juror to conclude that the elements of the crime as pled in the complaint were satisfied. Then you don't have a sufficiency error, but you might still have an instructional error, right?
Yes, I don't agree with your premise, Your Honor.
Right.
But
You're arguing both.
accepting your premise,
Yeah.
then yes, there's a separate issue, a potential issue of the instruction doesn't match the complaint, and that's an issue too.
And so that means we don't actually know whether or not the jury found beyond a reasonable doubt that the elements of the crime had been met by the evidence.
That's right, but that's a separate issue.
It's separate from sufficiency.
That's right.
Since we have you interrupted, let me get to another question that I had. On your lesser included offense claim, I didn't see where you specified what lesser included you wanted, and there would be two, it seems to me. One, I mean, if I remember right, one would be, more than one and less than 3.5 grams, and then the other would be less than 1 gram. So which lesser or both do you want, and then do the analysis from those two positions?
Sure. So the answer to your question is both, that it's our position in this case that, that there are lesser included offenses for the different levels on this case. And I recognize, and I think maybe even I mentioned when I was last before you on Zoom, that, I understand that there are other cases out there, and I have another case out there. And this issue of, does evidence of a greater amount.
Sure, and I can, and I can kind of, I guess I anticipated you could go with the less than one, because we have that little amount, that separate little amount that was in his jacket or pocket. But how is it factually appropriate to get on the over 1 and less than 3.5? Because as I remember, you've either got 1 maybe or less, or you've got 14. How do you get that middle lesser?
Sure. So there's a couple of ways. I guess my primary response would be, just because I have, let's say hypothetically, that I have 14 grams of methamphetamine, it's not a binary choice. I don't have to intend to distribute all of that or none of that. That a reasonable jury could, in any particular situation, say, well, maybe I intended to use some of it, and maybe I intended to distribute some of it, or maybe I had no intent with regard to some of it. That, I don't know, I had it for safekeeping to keep it away from kids. I don't know, something else, right? That I had no intent with regard to some of it. And so this idea that this binary decision, this all or nothing decision, that's not true as a matter of law. I mean, juries aren't restricted like that. And in fact, there's the big distinction between this case, I want to make it clear, between this case and what I think my previous case that I've argued here is, this is a jury trial case. And so a jury could reasonably. Now, additionally, juries could compromise too. I mean, how could you get to the lesser? Well, you could have, 6 jurors saying we think it's just simple possession. We have 6 jurors saying we think it was all with intent to distribute, and the jury compromises. And if they're given the option to say, well, here's this lesser, that they compromise it. Now, this court has acknowledged that compromise verdicts are valid, so long as what? So long as sufficient evidence supports the lesser included offense. And our argument is that a jury certainly could do that there is sufficient evidence in this case of the lesser, of both of the lessers.
Now, let me move you over to where you probably thought you were going to be at the beginning of your argument, which is the intent to distribute instruction on the rebuttable presumption stuff. Were you making an instructional claim or a constitutional claim?
It's, and I did hear the argument
Because
just
the
prior.
panel said one thing, and I'm wondering if that's right.
That's right. I'm making an instructional claim. And I want to make it clear that, that's, I think, the distinction and where we think the Court of Appeals went wrong here is that we made an instructional claim because we said that this instruction is legally inappropriate because the statute's unconstitutional, the argument that you've just spent a lot of time on. But the Court of Appeals said, no, you're raising this issue for the first time on appeal. Yes, but as an instructional issue. In fact, in every case where I'm raising an instructional issue for the first time on appeal, there's going to be a question of whether that instruction is legally appropriate, and that's going to be raised for the first time on appeal, right? When I say I should have gotten a lesser, there's going to be a question of, is that thing legally a lesser of the greater offense?
If we disagree with you that the statute, on the constitutionality of the statute issue, is there still a legal appropriateness issue between the instruction that's given, which was the same deal we just talked about, which was the permissive instruction as set out in PIC, and the rebuttable presumption that's specified in the statute?
Again, I just did listen to your argument, and so the answer to your question, Your Honor, is yes, although I have to admit, I didn't raise it as a separate instructional issue as an error just because it doesn't match the statute. I didn't raise it that way. But it's true, and certainly if you find in another case that it's legally inappropriate to give this permissive instruction in light of the statute, I think, again, you could recognize that that's an issue in other cases, like this case as well.
If there had been no statute, could this instruction have been given?
I agree with my colleague before. If there had been no statute, I don't believe there would be any legal basis. It would be legally inappropriate to give this instruction.
Some instructions are given as a matter of just common evidentiary law, let's say.
That might be true, but
why couldn't this instruction be one of those?
because there would be there's no basis at law for it. In fact, as I've thought about this getting ready for this case, and can I finish, Your Honor? As I think about this case, and because I've done this a little bit for a while, it's not new, it's not novel for this idea of, the state to put on evidence of the amount of drugs possessed, right? That's, as long as we've had possession with intent to sell or distribute, that's been a way that the state has proved intent. So that's not new, but what the statute does,
I'm
for
asking
an
you-
instruction,
Yeah.
is substitute an instruction for evidence. There's no legal basis as a matter of law to say what this instruction would say, absent.
In other words, if I could rephrase what I think you're saying, just because a certain amount of drugs is sufficient evidence for the state to meet its burden of proving intent, just because it's sufficient, doesn't mean that it's legally appropriate to tell a jury that they can make the inference of intent from that evidence.
Right, and I think this is a comment in the previous argument. That's the jury. Can a jury make that inference? Yes, that's not new.
But the legal error is not in the fact that the jury can't make the inference. The error is in basically telling the jury that.
That's right, and for example, Your Honor, and here's, as I think about this, I mean, again, we've had cases like this before. I mean, this is nothing new. You know, how much did that's a question that the prosecutor asks at a trial like this. You know, how much did this person have? He had 1,000 grams. Well, how much is personal use? 1/4 gram. So would you say in your, you know, maybe, first of all, maybe just the jury can from common experience say, well, that seems like a lot then. Or maybe they ask a follow-up question if the officer is qualified and say, well, can you tell me, is 1,000 grams, you know, appropriate for personal use? No, I don't think it is. But here's the thing, I get to cross-examine in that situation, don't I? I don't get to cross-examine this instruction.
So just to continue the line of questioning, there would be nothing wrong with a prosecutor in closing argument saying to the jury, we've proven X number of grams, and you know, you as a jury are permitted, and you really should infer an intent to distribute from that evidence. The prosecutor could make that argument, right?
If it's supported by the evidence,
Right.
yes.
And so help me draw the distinction between the prosecutor being able to legally make that argument, but the instruction being legally inappropriate.
Sure, and it's because it's conflating, and I'm trying to get, it's conflating the difference between an instruction, which is, I mean, and we assume that juries follow instructions. That instruction has this sort of judicial seal of approval on it, right? I can't cross-examine it. Again, as a defendant, can I stand up and argue you shouldn't infer that, even though the judge told you you should infer that? I can stand up and say, you know, the prosecutor said you should infer this, but it was really only this amount. It's very reasonable for you, jury, to assume that that wasn't with intent to distribute. I mean, I could do that if it's just an evidentiary issue.
The problem,
I can't do that if it's an instruction.
the problem with your response is that you're, I think, mischaracterizing the instruction. This instruction says may or may not. It says the burden still is with the state. So it doesn't say you should presume. It doesn't go that strongly. So I guess would make that comment you can respond to, but the other part of my question is there's also other evidence here besides quantity that the jury could look at to infer intent to distribute. You've got the sunglasses case with a large quantity, the client's DNA's on the sunglasses case, there's scales in there, there's extra baggies around. All of that permits the inference of an intent to distribute, right?
Well, I mean, we have a separate issue about whether there's sufficient evidence of intent to distribute in this case, so I'm not conceding that point, but I understand that that's the state's argument. To get to your initial question, Your Honor, I think, I mean, the problem is, and again, we've characterized, even in the previous case, that the instruction may be permissive, but what's its purpose then, other than to sort of put this judicial seal of approval on this inference, which otherwise would just be a judicial, evidentiary inference? What's its purpose? And I think the answer is only to influence the jury in a way that's improper. Let the parties put on their evidence, let the parties argue about what are reasonable inferences or not reasonable inferences based on the evidence, and leave it at that. Absent some other legal authority, it's our position that an instruction like this is legally inappropriate.
Add weight to that it's pretty specific and says if you find it's 3.5 grams, as opposed to just being an instruction that says you can infer from the amount of you know, the drugs that were possessed, whether, you know, that may go to intent to distribute.
Yeah, and Your Honor, I mean, and I admit that, I mean, that may have more to do with reversibility than some other things, but yeah, I mean, you know, if I have 3.6 grams, maybe it's more harmful than in other situations, but it's certainly, again, I don't understand, and maybe somebody else can tell me what the purpose of this instruction is if it's not to sort of put that judicial seal of approval on this evidentiary leap that should just be an evidentiary leap. I don't have anything else, Your Honor.
Question?
Thank you.
May it please the court, again, I'm Alex Driscoll on behalf of the state of Kansas. I suppose I'll start where the arguments just left off and work my way backwards through the points that were addressed. With regard to the issue of whether or not the jury instruction, I apologize. I need to gather my thoughts. This is my first appellate argument. With regard to the issue of whether the instruction on the weight presumption being able to be presumed to be evidence of possession with intent, the state believes that the Court of Appeals was correct in seeing this as a constitutional issue, while the issue was with the instruction. The only arguments made about why the instruction was not appropriate were constitutional. The defendant, the appellant, in his brief, only attacked the constitutionality of the underlying statute that allows for that presumption. The instruction matches that statute. Had the Court of Appeals heard arguments on this issue, it would have been only analyzing a constitutional issue, the constitutionality of the statute. While this is on its face an instructional issue, it's only wearing a name tag saying instructional issue. The meat, the bones, the skeleton of this is entirely constitutional.
Bolstered by the fact that the defendant did not argue legal appropriateness of the instruction later on, other than the Constitution and the factual appropriateness and all that.
That's
like we
correct.
would normally do if we were attacking an instruction that was error.
As to the issue with the jury instruction that was not requested, the state does believe that the Court of Appeals was correct, that this was invited error. This was more than just a mere failure to request a specific instruction. At the jury instruction conference, another lesser included instruction was requested by defense, and the state and trial judge both asked defense if they would want this other specific lesser included instruction. I believe it was the possession with intent between 1 and 3.5 grams. And in response to those questions, the defense stated that no, they did not want that instruction. There was an active refusal, defense actively declined to request the instruction. There was not a passive failure to request. There was an action taken similar to a situation in which the defendant would have requested a specific jury instruction and then not objected to it and then complained of it for the first time on appeal. With regard to the order from Friday with the sufficiency of evidence for felon in possession of a firearm, the state does concede that from reviewing the record, while the parties discussed a stipulation that would have included language that mentioned that the defendant had previously been convicted of a felony under Article 57, that was not part of the actual stipulation in front of the jury.
Could a reasonable jury infer from the stipulation that the state had proved the elements of the crime?
I believe there's a strong possibility that they could. Just the fact that the defendant stipulated to that element, that being the
Well,
prior
the
conviction
defendant stipulated to having been convicted of a felony.
of a felony within the past 10
And
years.
then didn't argue. I mean, I guess that
I think
the
that
same question. Is that enough for a jury to infer that the elements had been proved?
I could certainly envision a situation in which the jury, hearing a stipulation that included what it did, would take that to mean the defendant is not arguing that he has met all of the elements with regard to possession.
Not contesting those elements.
Not contesting those elements.
How does the jury infer from that stipulation an Article 57 conviction?
I don't know that they could have
It's
specifically
just-
inferred that.
It's not there. I mean, all you say is a felony, and there are a whole lot of felonies that can be committed, under the criminal code. So how do you infer specific felonies that are specified?
No, I don't think that you can infer those specific felonies. The situation that I could see is the jury seeing this stipulation as a willingness by the defendant to not contest that this aspect, these elements of the crime of felon in possession of a firearm had been met, but admittedly that's a stretch.
Was there any other evidence in the trial to show that there was a gun conviction within the last 10 years?
No, the only mention of the prior conviction was in the stipulation. It only included the details that were on the record. I'll briefly touch on the issue of sufficiency of evidence for possession with intent to distribute methamphetamine. There was sufficient evidence viewed in a light most favorable to the state for a reasonable trier of fact or finder of fact to find the defendant guilty beyond a reasonable doubt. There were 5 total baggies of methamphetamine located, one baggie being in the pants pocket of the defendant that was located in his pants after they were removed by EMS. The other 4 baggies being located in his sunglasses case in the common area of the home that the defendant told police he resided in. His DNA was on the outside of the sunglasses case. One of the baggies tested from within that case weighed over 14 grams. There were scales, with methamphetamine residue, other baggies empty, similar to those found containing meth. And
The appellant isn't arguing sufficiency of the evidence on this. So it seems like the pinpoint is this 3.5 or above. So why should we take into account any of the other evidence that may support distribution? I mean, aren't we just looking at whether or not there's a presumption of 3.5 or above?
well, I apologize. My reading of the appellant's brief was that the issue is whether or not he possessed that amount with the intent to distribute, that the issue is with intent. I may have misread that.
Right, I mean, that's the issue, but the point is the instruction, right?
I was addressing a different issue,
Oh, I'm sorry, then that's
the
my
defendant's
fault.
sufficiency of the evidence issue.
Okay,
I was just moving along. I heard no other questions about the instruction.
but would it be reasonable for a jury to have found that the sunglass case wasn't, even, I know there were fingerprints on it, but that wasn't part of the amount possessed?
I don't think that it would be. A possession just means that he has control over an object, an item, and the fact that it is in an area that he has access to, the common area of a house that he resides in, with his DNA on the outside of the case containing the meth and on the zipper containing the meth. No one else's DNA was found. No other DNA samples were found on that case. Indicates that he had to have had direct contact with that case. He had to have possessed it, had to have at least handled the zipper that opened that case at some point while that case was able to be accessed by the defendant. He had direct control over it. So I think it would not be reasonable for a jury to find that that's not part of the total amount. And adding to that, the bag or small baggie of meth found in the defendant's pants pocket was a similar kind of bag to the 4 found in the sunglasses case and to the other baggies that were empty and found in what appeared to be the defendant's bedroom. Touching briefly on the issue of the ineffective assistance of counsel, in a pro se sentencing motion, the defendant's only statement as to the effective assistance of his counsel was that the defendant and his counsel have not been in agreement on issues, and the defendant intends to pursue ineffective assistance of counsel options for appeal. In response to that, the trial court judge asked a series of open-ended questions trying to get Mr. Valdez to explain his dissatisfaction with his counsel's performance. Mr. Valdez gave reasons that he had not obtained all the discovery that he wanted from his counsel, he had not met with her as often as he would have liked, and that she seemed generally unprepared, and his counsel in response testified that she had met with him several times on several dates, responded to all of his emails, and provided him all the discovery that she was given by the state. And after this question and answer session, the trial court found that there was no need to appoint independent counsel or continue further, and the Court of Appeals was correct in applying Toothman's analysis, or Toothman's way of handling this situation that was controlling case law at the time.
Is defense counsel's responses to the district court judge's inquiry sort of rebutting the allegations that the defendant raised? Does that create a conflict of interest at that juncture?
I'm not sure that that early on it would create a conflict of interest so much as, I'm trying to figure out how to word this, it is both parties having an opportunity to lay out the facts to give the trial court enough information to determine whether or not there is a conflict. I just, by both sides, or both parties giving their side of the story may inherently create some level of conflict, but not to the level that an attorney would be required to be appointed.
Are you drawing a line that as long as the responses are factual and not an argument, that's where the difference would lie?
I'm not sure that that in and of itself would be the line, but I would also note that the defendant didn't contest any of those statements by his attorney. And I don't have the pin site off the top of my head, but I believe it's in the state's brief that the trial counsel, after the trial counsel had responded that she gave him discovery, she had met with the defendant on several occasions, responded to all of his calls and emails, that the defendant did agree that that was the case. It appears that after the questions had been asked and the attorney had been allowed to respond, that the defendant acknowledged that there was no real issue. So I don't know, to go back to your original question, if that on its own would be a line that I'm willing to draw, but with the defendant's own admission that the statements made by his attorney were correct. And as far as the issue of the constitutionality of the statute barring felons from possessing firearms, the state also agrees with or believes that the Court of Appeals was correct in not hearing this constitutional argument for the first time on appeal, given the fact that so little testimony, evidence, anything about this specific constitutional issue was developed at trial court. There's just no basis to even begin to analyze a complicated constitutional issue for the first time on appeal for the Court of Appeals in this case. Are there any further specific questions? I know I've bounced around quite a bit. Seeing none. Thank you.
Thank you, Mr. Driscoll.
I only wanted to bring up one point on my colleague's, maybe one of his last points was, the Court of Appeals refused to get to the issue regarding the constitutionality regarding the criminal possession of a firearm. And I just know, even in their brief, the state acknowledged that one of the exceptions applied in this case. They dealt with a fundamental right. I understand that, maybe that's a separate question then, still sort of the discretionary or prudential question of whether the Court of Appeals should reach it. But in this case, I don't know what else. And this discussion's been going on, in different Court of Appeals panels of what else is needed in order to resolve this question. So it's a legal question, and there's no the Court of Appeals didn't really set out any reason that they couldn't reach this issue effectively. And so
Still has to be an abuse of discretion on their part, not whether we would have made the decision differently. So where's the error of law? Where's the error of fact?
Yeah,
and where's no reasonable person would have done it? And that's the problem you've got.
Yeah, and as we've seen these Court of Appeals cases following, the decisions from this court, again, maybe there has to be some principled reason, though. Is it just completely arbitrary? Because I don't feel like it today. Is that a good enough? Is that an abuse of discretion?
Questions whether no reasonable panel would have made that decision. That's not arbitrary. That's just whether whether no reasonable panel would have made that.
I guess, and obviously, not surprisingly, I'm siding sort of with Court of Appeals justices that believe that in order to be able, if that's the case, it's completely unreviewable, right? It's completely unreviewable. there's no reason a court of appeals, or this court, I guess, will ever feel, there's no way, I don't even know how I would come to court and argue, here's why you should do this, right? Here's how you should exercise your discretion if you're not giving some guidance on, here are cases where you should exercise this discretion this way, and here are cases where you shouldn't. Now, I understood and understand that there might be some cases where you go, because of, I don't know, procedural problems or whatever, we're not reaching this. But that's not what the Court of Appeals said here, that they have any reason that they couldn't get to this issue, just that they're not getting to this issue. And so I guess that's, I don't know. I mean, I don't know where we're going to end up on this.
It sounds like you're saying that it's no reasonable judge would have reached this conclusion, would just say, we're not going to do it because we don't feel like it. I mean, I'm not characterizing the Court of Appeals that way, but it sounds as though that's essentially your argument.
That you would still say, okay, that's okay.
In other words, in order for a Court of Appeals panel to not abuse its discretion, it has to articulate a reason.
I mean, I don't know if it has to articulate or it has to be self-evident in some way that there's a problem in this situation. Obviously, the best way to do that, I mean, when you think about district courts exercising discretion, I mean, sometimes you look at it and, they may articulate a reason or not, but there's some review of it still, depending on whether it's articulated or not. Articulating a reason can certainly help, I think, a reviewing court say, well, that's reasonable, that's a reason that we're going to accept. And in the absence of that, maybe it's just a different review. But if there's no review at all, then that seems problematic.
So you're saying that, what the Court of Appeals said was that to dive into this issue would require factual, legal, and historical analysis not found in the record.
Right, and what I'm saying is that's not true.
Where's the historical analysis in the record? It's raised for the first time on appeal.
Yeah, I mean, the historical analysis is in my brief, where I talk about when Section 4 was amended in 2010, and what the law was before that, and what the law was after. Now, maybe, and wouldn't be surprising necessarily, maybe you say, we don't think that was a good enough analysis in your brief. But there's no factual, what's my factual development going to be if I was going to raise this at the district court? What would I bring in that I can't bring in on appeal? I mean, if the idea or the assertion is that it's not briefed well enough, I don't know, maybe that's the case, that I haven't briefed the historical record enough.
What it says here is that Valdez would need to articulate something in the history of the Kansas Constitution and case law that would suggest that Kansas courts should depart from their long history of coextensive analysis of rights under the state and federal constitutions.
And I made that argument. Now, and maybe this is the fundamental kind of issue is, and we're seeing this maybe more and more, this idea of there's a difference, there's a difference between like not making a persuasive argument and not making an argument.
Or how about making an argument with the district court on this same subject?
Yeah, I mean, let's think about this. And in fact, I train attorneys. And so now it tell somebody, we're getting all these decisions that say we can't get to this issue because you didn't raise it. So what are we going to have? We're going to have district court attorneys saying, Your Honor, my client's charged with criminal possession of a firearm. We object under Section 4 of the Bill of Rights of the Kansas Constitution. And is that enough? I mean, now it's not raised for the first time on appeal. It was raised below. It's the district court going to say, well, I'm going to reach this issue now, even though the Kansas courts have never said anything about this issue? Or will the district court do the same analysis that you would be doing right here today? I don't see the difference. I don't see what the development, what witnesses am I going to call at the district court that would be different than the analysis that I would be able to bring to this court. I don't see the difference.
Real briefly, I know you're out of time, but can you just briefly explain this whole inference stacking sufficiency of the evidence? Because obviously I got that mixed up, and I didn't really get the inference stacking part.
Sure. So, and I agree with my colleague that, there is a separate issue here regarding sufficiency of the intent to distribute. And so the inference stacking argument in this case is the state's assertion is that particularly that the possession of the drugs found in the sunglasses case was with intent to distribute. And so first of all, they have to find out my client possessed those drugs. And so,
And is that possession based on an inference or not?
yeah, I mean, the inference in this case is that my client possessed the things that are inside the sunglasses case because his DNA is on the outside of the sunglasses case. That's not direct evidence, that's circumstantial evidence, right? Maybe he just handled that sunglasses case at some point. But I admit that's circumstantial evidence, right? That from which a jury could infer possession of the drugs inside the sunglasses, of the sunglasses case. And then they're going to say, and we're going to infer that he knew what was inside the sunglasses case. I don't know what evidence there is particularly in this case to show that there's, if there was some evidence that, well, he must have known it, or he admitted it, or it was out in the open, it was open on the counter. I mean, that might be evidence from which. So that could be how you could try to get an inference that he possessed the things that were inside the sunglasses case. But on top of that, there has to be an inference that my client intended to distribute that they intended to distribute what was inside that sunglasses case. And that's where our argument is, Your Honor, that, I mean, it's the building of the stacking of these inferences to get to that last one, that even if it's a proper inference that my client possessed the sunglasses case, that's the limit of that inference.
And again, I'm sorry, I know you've been held over by our questions, but hopefully.
I love being here, don't worry about it.
I just wanted to get a clarification from your perspective on the state's claim that at the instructions conference, the defendant affirmatively declined to request lessers. Is that true?
It's definitely not true, Your Honor. I mean, again, it's definitely true that my client did not request this instruction. And it's definitely true that my client's attorney said, our theory is that he didn't possess the things in the sunglasses case, but maybe he possessed the things that were in his pants, that were found in his pants pocket, which was 1 gram. And so that's why the theory there from defense counsel was, we want a simple possession instruction, which the judge gave, that maybe he only had the drugs that were in his pants, and a jury could find a reasonable doubt about the drugs in the house.
Was that the state, my understanding was that the state just argued that defense counsel was specifically asked, do you want these other lessers of the lesser amounts? And the defense counsel said no.
That's right.
That's correct.
That is correct, Your Honor.
So earlier you talked about a jury's compromise verdict when you were arguing in favor of these lessers. Isn't it the defendant's prerogative to remove the possibility of a compromise verdict from the equation?
Yeah. Well, my answer to your question is no. I mean, I think it's always ultimately the judge's job to decide how to instruct the
So a
jury.
defendant does not get to take the possibility of a compromise verdict off the table. That's your position.
It's my position that the parties don't control what instructions are given by the judge. The judge describes with it. But underlying your issue, Your Honor, I mean, the dispute we have between my colleague and I is the failure to, or even saying, I don't want that instruction, is that the same as saying, I object to that instruction? That's the real disagreement here. And our position is saying, when the judge says, do you want this instruction? And my client's attorney says, I'm not asking for those instructions, that's no different than just not requesting them. That the judge says, I'm giving this one and this one. Does anybody have any objection to that? No. It's the same position. Now, if my client had said, Your Honor, I want to pursue this all or nothing defense, and I object to you giving that instruction because I don't think there's evidence to support it or whatever, or because we want to play the game here and we want to roll the dice. And the judge said, all right, based on your objection, I'm not giving that instruction. I think that's invited error. But that's not this case, Your Honor.
One more question, just to make clear. The less than one, I guess that's also, did he decline that one, affirmatively decline? Both of them, or just the one?
It's the same with regard to any of the lesser included offense
Oh,
instructions.
okay,
The
got
argument's
it.
the same. There was no distinction between them.
Okay, got it.
But it's my position.
He used the term lessers, or
That's right.
she, whatever the court, yeah.
Questions?
Thank you, Your Honor.
Thank you to both counsel for your arguments. We will take this appeal under advisement.